What does a copyright owner have when they own a copyright?
So, as the name suggests, the first and most basic right was the right to make copies. But out of that grew some other logical rights, like the right to distribute copies. In addition to that, the right to make a derivative work, to take the work as it is and make some new work out of it based on it, is a right that belongs to the copyright holder. With respect to the work, in addition to making copies, distributing those copies, and making derivative works, the author also has the right to either publicly display or publicly perform the work. Whether it's publicly displayed or publicly performed depends on the nature of the work. Generally speaking, pictures, sculptures are publicly displayed. Music, dramatic works are publicly performed, but the right is functionally the same. And then the last right is a species of public performance that's very specific to sound recording, whereas all of the other rights I had mentioned are essentially universal. Congress for many years allowed no rights at all in public performance of sound recordings, but about 20 odd years ago changed its mind, but only with respect to digital broadcasts and digital transmissions. As a practical matter, this means basically Sirius XM satellite radio and Pandora, non-interactive streaming services.
I'd like to add on to what Josh said. For those who are copyright nerds, the bundle of rights that a copyright owner has in a copyright is set forth in Section 106 of the Copyright Act, and that is exactly the list that Josh just explained. I'd like to follow up on illuminating two aspects of the bundle of rights that Josh touched on. The first is a derivative work, which Josh perfectly explained it in the abstract, but it's much more easy to understand given a specific example. So, for example, if I write a novel and Josh is a film producer and wants to make a movie out of that novel, I, as the copyright owner in that novel, would have to grant him permission to make a derivative work, a work that is derived from my original work, to make a movie out of that original novel. So that's one example of a derivative work. One of the areas that I practice in most is in music. So for example, if a work is originally a hit pop song and somebody wants to make an SATB, a soprano, alto, tenor, baritone arrangement for school choir, which happens all the time, that again needs permission from the copyright owner of that work, which, as we'll probably explain in future segments, is typically a music publisher. And that arrangement is a derivative work of the original pop recording music that was first released. So those are two examples of derivative works. I'd like to also touch upon the limited right in the public performing right in a sound recording that Josh touched on. So, for example, the example that I always use is the recording of New York, New York by Frank Sinatra. And that is a song written by Kander and Ebb and recorded by Sinatra, I believe either on Capitol or Reprise Records. And so when that song is played on the radio, because the underlying song enjoys broad public performance protection, Kander and Ebb, as the songwriters, and their music publisher get paid for those performances through what's known as a performing rights organization, which we'll touch on in future segments. However, the estate of Frank Sinatra and his record label get paid zero, because it's not a performance by a digital audio transmission, as Josh pointed out, which is basically Sirius XM and streaming. For what we lawyers call traditional terrestrial broadcast, free TV and AM FM radio, the copyright owners in a sound recording get paid nothing. And that is only in the United States, Iran, and North Korea. The rest of the world pays recording artists and record labels just like they pay songwriters and music publishers for those public performing rights.